Good morning, everyone. This meeting is now called to order. My name is Rhea Untitled Chapter, and I'm chair of the HART Litigation. Welcome to the June 22nd, 2021 Litigation. The meeting format is hybrid. Quorum is physically present at the HART Administrative Office, 1201 East 7th Avenue, and the rest of the board members are participating in the Thank you for the allegiance. Please look at the screens of your devices. The image of the flag is displayed. Please join me in
Pledge allegiance to the flag of the United States of America and to the republic which stands one nation under God.
I don't have any volume. I'm sorry, and I don't even know if anybody can hear me.
Is that better? Can you hear us now, Julie?
Now I have volume.
Okay.
Now I can hear you.
User error. Staff, please do the roll call and list other attendees.
Good morning, this is Danielle from HART. Director Frazier.
Here.
Director Kirk. Here. Committee Member LeGrand.
here.
Committee Member Mandel.
Yeah.
Committee Member Wright.
Here.
Also present, we have Michael Rosen, myself, Danielle Arthur, and Terry Wright from HART, and a court reporter. Thank you.
I would like to draw everyone's attention to page 3 of the packet to review rules for meeting participation. Next is public comment, but there was no one pre-registered to speak. Next on our agenda is summary of action items. Mr. Michael Rosen, Senior Litigation Staff Attorney, will introduce and summarize the action item. Mr. Rosen, you are recognized.
Thank you. Good morning, Madam Chair and committee members. Michael Rosen, Senior Litigation Attorney. We have two agenda items this morning, one tort claim for the closed session, and once we are back in the open session, Mr. Wright and I will give you a brief overview of the internal claims process and try to answer any questions. Just as a reminder for the closed session, if you're not on the Litigation and Claims Committee or the court reporter, you will not be permitted to attend the closed session. The claim today is identified by claim number 101-7682, and the time is 9:03.
Wonderful. So are we ready to commence the closed session? As chair, I'm announcing the reopening of this meeting. During the closed session, the committee formed consensus on the following action item. Authorization to increase settlement authority to $65,000 on HART liability claim number 101-7682. Is there a motion to approve committee action item authorization to increase settlement authority to $65,000 on HART liability claim number 101-7682?
I'll move to approve. Julia?
Thank you.
I would second if necessary. Jason?
Thank you. So we have a motion and a second. Staff, will you please take a roll call?
Committee Chair Frazier.
Yes.
Committee Member LeGrand.
Yes.
Committee Member Mandel.
Yes.
Committee Member Kirk.
Yes.
Committee Member Wright.
Yes.
The motion passes unanimously. Thank you.
Thank you. Next is the information item, HART risk management claims process that was requested by committee member Mandel and will be presented today by Mr. Rosen. You are recognized, Mr. Rosen.
Thank you. And actually, Mr. Wright's going to assist with this. So at the last meeting, there was a request to, I guess, gain some insight into how we manage and, these claims both at before a lawsuit is filed and after a lawsuit is filed. So Jason deals with the claims before the lawsuits are filed, and then they come to me. So I'm going to pass the baton to him and let him discuss that. And when he finishes, I'll discuss the litigated part of the cases.
Okay. We kind of did this in an informal format, but I just want to apologize. I was going to give you the whole picture. If I start rambling on too much and you just want me to get to the meat of it, please let me know. Basically, I'll start at the birth of the claim. An accident or incident occurs. Typically, the bus operator is there, fills out a report. If it rises to the level of needing a supervisor would also go out and complete a report. Those reports are received in OCC every day, and myself or one of my staff members would go get those reports, review them each morning, and determine which ones would warrant a claim being set up. Now, that could be either a claim where we're at fault, which we call a non-billable claim, or a claim where there's a third party that caused the accident and we have damages to recover from them, which we consider a billable claim. Once those claims are set up, they're set up with our TPA, which is Johns Eastern Company. TPA, for everyone, that's third-party administrator. They handle our claims, handle reserves on our claims, and basically just administer the claim throughout the life of it with our oversight. We make the initial liability determination, like I said, and we tell them how we want to pursue the claim at that point. We start to gather the evidence, whether it be photographs, video, statements from our employees, statements from witnesses, and then, more importantly, on the non-billable claims, we would start to see what kind of defenses we might have, if any. Obviously, a claim like today, we didn't have any, so we would want to try to settle that as quickly as possible. Obviously, claims don't get cheaper the longer they're open, so that's just kind of how the directive we've been given over the years and how we try to pursue things. Some of the tools at our disposal, obviously, are the surveillance video. If we think somebody is kind of faking or malingering, we might put surveillance on them, which is a private service that we would pay for. Obviously, we take those expenses into account, so making a business decision on whether that would be worth it. Settlement authority levels, I'm sure you guys know. Anything under $50,000 doesn't require the committee approval. Anything over 50 up to 100 is committee. Anything over 100 is the board. The TPA does not have any authority on bodily injury claims without my approval. We have given them desk authority on property damage claims because they require appraisals to verify the damage amount. So anything that's a property damage, they would still need my approval, but we give them a little more carte blanche to handle that and get them out of the way. Other than that, if a claim is valued at a certain level by our adjusters at Johns Eastern, my staff, all of whom are also licensed adjusters, including myself, we evaluate them ourselves. We come to a consensus with them. If it meets committee thresholds or whatever, we'll even bring in Mike Rose and get his opinion on it before we bring it to you guys. If we can't get it settled, obviously, they have the right to file a lawsuit, at which point we turn it over to legal. And you want to go from there?
Sure. So once the lawsuit is received, it's reviewed by in-house counsel and assigned to a paralegal. When a lawsuit is filed against a governmental entity for a tort claim, there's different rules that apply than as to a private entity. So they have to follow the Florida statutes, and one of the biggest hurdles is that you have to wait 6 months before you can file a lawsuit. So you have to give notice to the governmental entity, and the purpose for that is so that they can try to work out the claim. And the 6 months is there because sometimes the wheels of justice move a little bit slower, with the number of claims and bureaucracy, if you will. So after the 6 months expires, they can file the lawsuit. We get sued on a regular basis. Currently, I'm handling all of the tort lawsuits that are filed against HART. If there's a conflict of interest or a workload issue, we would go outside. All of the worker comp cases are handled by outside counsel. So another one of the differences between the private sector and the government sector is their sovereign immunity. So by Florida statutes, it's $200,000 per person, and $300,000 per accident. So if there's 10 people on the bus that are injured, the most that, even though it's $200,000 per person, the cap of $200,000 or $300,000 per accident would control. And we've had those kind of cases before. So you have claimants that would be subject to that ultimate amount. And the only way to get more than the sovereign immunity limits is to have a claims bill, which means it has to go to the Florida legislature and be approved, and that's a very long and difficult process. So since I've been here the last 8 years, we haven't had any cases go through a claims bill. In terms of the number of cases or the types of cases, we have everything from I scraped my knee on the bus to a wrongful death claim. We've had, I think, 3 or 4 wrongful death claims over the last 8 years. Most of the claims, I would say, are between the 20 to 50, somewhere, in that type of. Presently, I have about 35 to 40 lawsuits, pending lawsuits that I handle by myself. Once the lawsuit starts, the parties engage in what they call discovery, which is an exchange of information. So there's depositions. We do those on a regular basis. They take our, the bus operator or the streetcar operator or the paratransit operator. I would take the deposition of the plaintiff that files the lawsuit. For the last year or so, we've been doing Zoom depots, and everything's been done by Zoom. All of the hearings in court are done by Zoom as well, and I think everybody seems to like it because you go to the courthouse, it takes you 2 hours to go, and you can do it in a 15-minute hearing. We're required to mediate all of our cases. There's a representative from the risk department that attends the mediation. I've talked a little bit before as far as compulsory medical examinations. So the defendant gets to pick the doctor that the plaintiff has to go to, and then that doctor does a physical examination of the plaintiff and prepares a report, and the report goes to both sides. And in cases where we're not able to settle the case proceeds to a jury trial or non-binding arbitration. So I've tried, I think, 5 jury trials, and we've had, and there have been 2 that have gone to arbitration. As far as the jury trials, we got 2 complete defense verdicts. In the other cases, one was over the sovereign immunity limit so that they were capped, and I think the other ones were kind of a middle ground. So that's, in a nutshell, the process. In terms of reviewing the process, it's really a group effort. As far as what we come up with, as far as the settlement amount, based on the legal director and the risk department, our desks are not far away from each other. And we talk about the claims every day, and all the, everybody has a lot of experience, doing this. And then, of course, the cases that are over the threshold go to the committee or ultimately to the board. So that's all I have. Have we got to answer any questions you have?
I did have one more comment, too, just to let you guys know a little history of the committee here. I've been tracking it and went back since about 2017. We've had 20 items that required committee approval. I know we've been doing this a lot lately. Usually we don't see you guys, but maybe 2-3 times a year?
Maybe.
And of those 20 items, only 5 required board approval. So just to kind of give you that information.
Okay, thank you. Ms. Mandel?
Thank you. I had asked to do this because although I've been involved in claims processes before, I wasn't sure everybody else had, and I think it's important to put this process in context. One of the questions I do have, though, is how that determination, it sounds like we make all these determinations of liability, then how do we document those those determinations. Now I recognize that cases that come to us probably have already had that determination made, but I'm just curious the process you go through to determine liability, and then how do you document it? Do you document that within the body of the claims file, or is it documented in such a way that it's discoverable?
I can answer that.
Go ahead.
Basically, Julia, the entire claim file is handled by the third-party administrator, and that kind of serves the purpose of keeping our hands out of it. It's required for audit purposes to have those, impartial people handling the claims file for us. Obviously, I do have a say in the liability determination, and I have counsel at my disposal anytime I need it. But to answer your question, it would be documented in the claims file, either via a note in the claims file by the adjuster or the supervisor, based on our conversation.
And the reason I asked that question is I noted in some of them there seems to be almost like a write-up of liability that was occurring, and I just was curious as to how that was handled, because if it's part of the claims file, it's definitely not subject to a public records request. I don't recall, because it's been a long time, if that determination is discoverable. But that's not to say that it's not important to be able to make that determination and to make decisions as it relates to settlement. My only I don't want to say concern, but my only question is how do we ensure, as we're reviewing a claim file, or reviewing a claim, that if we're making an internal determination of liability, that is something that is remaining in internal decision.
That concerns me as well, for obvious reasons. Obviously, 76828 has that provision that keeps the entire risk claim file confidential or exempt from
Confidential and exempt
from public disclosure. So, we treat all claims emails, pretty much all of my emails are exempt from public disclosure or public records requests as well, just based on that exemption. I think the only concern would be the action item write-ups like we had for today, but they become public records once the case is resolved anyway, so I don't really know what else you're asking as far as that goes.
Well, really what I guess I'm trying to say is whenever you create a scheme under which you're making determinations of a claims process, and having been involved in those processes in other governmental entities, I just think you have two questions that you're involved with. One is each individual claim, and then you're also involved in more just the generalized, do you want to become the target of all the plaintiffs in town? So I just, that's why for me, in looking at some of this stuff, I was just wondering how we were ensuring that we could do a proper investigation so that you can make decisions whether or not you want to early settle a claim in order to avoid litigation expenses, which is as important a decision as to say, wait a second, we're taking this one forward, and how does that resonate in a larger scale of things? Because there is a larger scale of things. I've seen the larger scale in other situations, so it's not something you need to answer, it's just something that I'm noting, and I just wanted to be able to ask procedurally how we get there, but also maybe to think through maybe how we're ensuring that we're not becoming targets of not to talk about claims first. Not talk about lawyers at all, because I am one. But the bottom line is part of the robust claims process ensures that it's a well-known fact that an agency won't just settle for the sake of settling. That they will take something forward if we feel very strongly that it's a case worth bringing forward. That's my editorialization, and I appreciated the presentation.
Can I add just one point from a practical perspective? The buses, paratransit, and streetcars are all equipped with surveillance cameras. So once the lawsuit is filed, then we turn over a copy of that. So, they have the actual accident, on video. So there's, it takes a lot of the guess games out as far as who's at fault. I mean, of course, there's still issues, but once the lawsuit's filed, they're getting a copy of the surveillance of the accident.
Yeah, and I would even go further, Julia, to say, I think I get what you're asking, and we are somewhat of a target. And I won't name the firms in general, but there's two specific that we get most of our lawsuits from. And in the past, we've had to select, one or two that we think we have a good chance of winning, even though we might not be, wholly off the hook. But Mike Rosen has gone to trial on a couple of them and gotten 0 defense verdicts and whatnot. So, yeah, that is a very important part of it. We do have to fight back. But unfortunately, a lot of times we're fighting a losing battle because of the liability. So,
Understood. Sometimes this is an art, not a science.
yeah. I hope I answered your question.
Are there any other questions? Nope. Okay. Thank you. I appreciate that. I think that was helpful. Wanted to make sure that we didn't give away privileged legal strategy with our discussion, but
That's always a concern.
right. But I think that was helpful. Is there any more to the presentation?
No, that concludes that.
Wonderful. Is there any other business to come before the committee? All right, hearing none, the meeting is adjourned.
Thank you.
Thank you.
Thank you all.